The home you spent decades paying for could become the very asset the government uses to recover the cost of your nursing home care. What makes it even more surprising is that the claim usually doesn't happen while you're alive. It often arrives after you're gone, when your family expects to inherit your estate. A federal law known as the Medicaid Estate Recovery Program, MERP, requires every state to seek reimbursement for certain long-term care expenses paid through Medicaid. If Medicaid covered your nursing home stay, and in 2026, the average cost ranges between $9,000 and $11,000 per month, the state keeps track of every dollar it spends. After your death, it may file a claim against your estate to recover those costs. For many families, the largest asset left behind is the family home. That house you worked your entire life to own free and clear can become the primary source used to repay Medicaid benefits before your heirs receive what's left. This isn't a new policy or a recent change. Federal estate recovery requirements have been in place since 1993. Yet millions of Americans are still unaware that these rules exist until their families encounter them firsthand. But the reason most families only find out about it after it is too late is because nobody in the system has any reason to warn you. The hospital social worker who helped your mother qualify for Medicaid told you the house was safe. The nursing home admissions coordinator said your mother could keep the home as long as she intended to return. And both of those statements were technically true while she was alive. The moment she passed away, the rules flipped. The home became a recoverable asset and the state filed its claim. What I am going to walk you through is exactly how this works, exactly who it affects, and 4 legitimate legal strategies you can put in place right now to make sure your home passes to your family and not to the state. These are real. These are legal, and every single one of them requires you to act before you need care because once you are in a nursing home, the window has already closed. The first thing you need to understand is why Medicare does not save you. Most people assume that because they paid into Medicare their entire working life, Medicare will cover a nursing home when they need one. That assumption is wrong. Medicare covers what is called skilled nursing care, things like physical therapy after a hip replacement or wound care that needs a registered nurse. And it covers that for a maximum of 100 days. After day 100, Medicare stops paying entirely. But 85% of people in nursing homes are not there for skilled nursing care. They are there for custodial care, help bathing, help eating, help getting dressed, help taking their medication, help not wandering outside at 3 in the morning because the dementia took the part of the brain that knows where the front door leads. Medicare does not pay for custodial care, not for one day. In 2026, the average cost of custodial nursing home care in this country is between $9,000 and $11,000 a month. In a memory care unit, you are closer to $8,000 for assisted living and significantly more for a full nursing facility. The median retirement savings for an American 65-year-old is roughly $280,000. That entire nest egg gets burned through in about 2.5 years of nursing home care. After that, the family applies for Medicaid because Medicaid is the only government program that covers unlimited custodial long-term care. But Medicaid is a poverty program. To qualify, you need to have $2,000 or less in countable assets. $2,000. Your savings, your investments, your life insurance cash value, almost everything has to be spent down to almost nothing before Medicaid steps in. The one asset that is technically exempt during your lifetime is your home, as long as you have the legal intent to return, but that exemption ends the day you die. The second thing you need to understand is the 5-year look-back trap. Some people hear all of this and think the solution is simple. Just give the house to the kids before you need care, and the state cannot touch what you do not own. The federal government anticipated that move decades ago. When you apply for Medicaid, the state goes through every financial transaction you made in the prior 60 months. 5 full years of bank statements, real estate transfers, gifts, everything. If they find that you gave away assets or sold them for less than fair market value, they impose a transfer penalty. The penalty is calculated by dividing the value of what you gave away by the average monthly cost of care in your state. On a $300,000 house in a state where nursing home care costs $10,000 a month, that works out to a 30-month penalty. 2.5 years during which you cannot receive Medicaid. You need care, you cannot pay for it, and Medicaid will not cover you because you tried to give the house away too close to when you needed help. This is why last-minute planning does not work. The architecture has to be built while you are still healthy, still walking, still mowing your own lawn. Every month you wait, the 5-year clock starts that much later. Now, here are the 4 strategies that actually protect your home. Each one is real, each one is legal, and each one works differently depending on your state and your situation. Strategy number 1 is the Medicaid Asset Protection Trust, sometimes called a MAPT. This is the most powerful tool available to middle-class families in 2026. It is an irrevocable trust, which means once you transfer your home into it, you no longer legally own it. You continue living in the house, you continue paying the property taxes, you continue maintaining it, nothing changes from the outside. But legally, the home belongs to the trust. Once 5 years have passed from the date of the transfer, the look-back window has closed and the home is completely invisible to Medicaid. When you die, the state files its MERP claim against your estate, but the house is not in your estate. It is in the trust. The trust distributes the home to your children free and clear. The cost to set up a properly drafted MAPT through an elder law attorney runs between $3,000 and $10,000, depending on your state and the complexity of your situation. On a house worth $300,000 or more, that is the best money you will ever spend. Strategy number 2 is the caregiver child exception. This one is written directly into federal Medicaid law, and it is one of the cleanest exemptions that exists. If an adult child moves into your home, lives there for at least 2 continuous years immediately before you enter a nursing home, and provides care during that time that allowed you to stay home rather than go into a facility sooner, you can transfer the home to that child with 0 look-back penalty. The transfer is exempt. The requirements are strict. The child must be a biological or adopted child, not a stepchild or grandchild. The 2 years must be continuous and immediately before your institutionalization, and there must be documentation, medical records showing you would have needed facility care without the child's help, a caregiving log, and ideally an attorney structuring the transfer. But done correctly, this is a complete escape from both the look-back penalty and MERP recovery. Strategy number 3 is the Ladybird deed, also called an enhanced life estate deed. This is only available in a handful of states including Florida, Texas, Michigan, Vermont, and West Virginia. A Ladybird deed lets you retain full control of your home during your lifetime. You can sell it, you can mortgage it, you can do whatever you want with it, while automatically transferring the property to your named beneficiary when you die without going through probate. Because the home never enters probate, many states cannot recover it through MERP. In Florida, a Ladybird deed is one of the most powerful and least expensive Medicaid protection tools available. An attorney can draft one for between $400 and $1,000. It does not help you qualify for Medicaid, and it does not protect the home during the look-back period. But for MERP recovery after death in the states that recognize it, it is devastatingly effective. Strategy number 4 is for married couples, and it is called the Community Spouse Resource Allowance. When one spouse needs nursing home care and the other does not, federal law allows the healthy spouse to keep a protected amount of assets. In 2026, the maximum Community Spouse Resource Allowance is approximately $157,000 in countable assets, plus the home, plus one vehicle, plus various other exempt categories. The healthy spouse keeps that allowance and continues living in the home. The home cannot be sold while they are living in it. In some states, including New York and Florida, there is also an aggressive technique called spousal refusal, where the healthy spouse formally declines to make their income and assets available for the institutionalized spouse's care. This forces Medicaid to evaluate the nursing home spouse based only on their own resources, which can accelerate eligibility significantly. The state may later attempt to recover from the healthy spouse, but the immediate Medicaid qualification is preserved. Now, here's what I need you to understand about timing. Every one of these strategies works best when you are healthy. The MERP needs 5 years to clear the look back. The caregiver child exception needs 2 years of documented live-in care. The Ladybird deed needs to be recorded before you need Medicaid. The spousal protections need to be in place before the nursing home admission. Once the crisis hits, once the fall happens, once the dementia diagnosis lands, your options shrink dramatically and the cost of whatever protection you can still get goes up. The average American over 65 has a nearly 1 in 3 chance of needing some form of long-term care. The average stay in a nursing home is just over 2 years. The average cost over that stay can easily reach $200,000 to $300,000. And MERP operates in every single state in the country. So here's what you do. Step 1. Find out how your home is titled right now. Is it in your name alone? Is it joint tenancy? Is it in a trust? You need to know. Step 2. Find an elder law attorney in your state, not a general attorney, not a tax preparer, an elder law attorney who specializes in Medicaid planning. The National Academy of Elder Law Attorneys maintains a directory. Step 3. Schedule the consultation. It will cost you between $200 and $750. That consultation will tell you which of these 4 strategies fits your state, your situation, and your family. Step 4. Start the clock. Whatever the attorney recommends, get the paperwork done, because every month you wait is a month the 5-year window slides further back. I will put all the details and links in the description below. Send this to someone in your family who owns their home and has no plan for this. A parent, a brother, a sister, someone at church, someone you care about, because right now the most common way families find out about MERP is from a certified letter that arrives after the funeral. By then, the house is already on the line. One share from you changes that. I will see you in the next one.